much, Mary, for that. I think I should sit down now because there's no way I can top that introduction. I'm very happy to be here. Thank you for inviting me. I'm very happy to have heard José there, who was my PhD supervisor in law in Leicester. So thanks for that, José. Well, I'm going to change the tone a little bit here. I am a clinician. I'm a practicing psychiatrist. I'm going to talk exclusively from that perspective. And I'm going to, in fact, yes, this is how I see myself. And José spoke about the poor medics who were caught in the middle of this, and the flummoxing nature of some of the dilemmas that we face in practice, that we absolutely need to find solutions for within very short periods of time. And my theme is going to be primarily the huge disjunct or distance between much of what's in the law and medical practice. The sheer complexity, the highly personalized nature of individual medical encounters, to the point where one could say they're almost unregulatable or ungovernable. And yet, the history, particularly of my discipline, psychiatry, is very, very clear that doctors, and in particular psychiatrists, need to be regulated. We have enormous powers, particularly in psychiatry, powers of coercion, without necessarily going to courts. So the need for regulation is incredibly pressing, and it needs to be as firm as possible. There needs to be a legal bedrock, but there also needs to be a very a nuanced medical ethical dimension. But I'm going to talk a little bit about the law. I'm going to focus on two examples of recent interest: the Mental Health Amendment Act, which was commenced in February, and the Assisted Decision-Making Capacity Act, which has been signed by the President but not yet commenced. But it may well be commenced. I'm going to use these two specific examples to demonstrate the distance between what's in written law, if you will, and medical practice. I'm going to look at the Mental Health Amendment Act firstly. This concerns people who are detained under mental health legislation. The current position is if somebody is detained, this is for a detained person, their consent is still required for treatment, except where, in the opinion of the psychiatrist, the patient is, and look at the final lines there, incapable of giving such consent. So if someone is detained against their wishes, involuntarily admitted, their consent is still needed for treatment unless they lack the mental capacity to provide that. Okay? And we know that some detained persons do have mental capacity, and we know that some voluntary patients do not have mental capacity. There's a paradox there. But for the detained patients, consent is needed, except in specific cases. Section 58 concerns psychosurgery. We're not going to talk about that. But the 2015 amendment concerns the other two, 59 and 60. Okay, so consent is needed even if you're detained. For ECT, ECT shall not be given to a detained patient unless the patient gives consent, or if the patient is unable or unwilling to give consent, you get a second opinion. Okay, so ECT for a detained person can be given if they have capacity and they consent, and if they're unable or unwilling to provide consent, you get a second opinion. The change that we have seen this year is they've deleted the word unwilling. Okay, so for a detained person, ECT can be given with consent if they have capacity, or if they don't have capacity, you need a second opinion. There's no possibility of giving it to a capacitous person who is simply unwilling. But how many of these are there? How many detained people every year in Ireland are given ECT solely on the basis of being unwilling to receive it? How many people will this deletion of unwilling actually affect in practice? It was a widely agreed change. It sounds very good in theory, but on the ground, who will it affect? If we look at the Mental Health Commission figures here, ECT without consent, 2013, one person received ECT solely on the basis of the unwilling part of this piece of legislation. When you go to the previous year, it's the same again, one person, now hopefully not the same person, repeatedly getting ECT. But I think the point I want to make is that while it's important certainly that the law is correct and adheres to the various principles in this, things can be quite different. The effects can be quite minimal on the ground. The other change brought in was very similar. It's for when a detained person has been given medicine for a continuous period of 3 months, You shall not continue it unless the patient gives consent, that is, a detained person has capacity and consent, or else, if they're unable or unwilling to give consent, you get a second opinion. Okay, so very similar to the ECT. And what the new amendment did was it deleted the word unwilling. So you cannot give medicine for more than 3 months to a capacitous person who's detained. But what's interesting here is, how would you ever get to this point? Because for the first 3 months of the admission, you can only give the medicine if the person lacks mental capacity. So the total number of people likely to be affected by this change is actually 0, because this concerns 3 months and onward. And to be treated up to that point, you must have lacked capacity to begin with. If you were simply unwilling, you couldn't have been treated for the first 3 months at all. So the number of people affected by this change will probably be 0. So what was the point of the 2015 Act at all? Was it simply to sort of do something, be seen to delete unwilling, even though the numbers affected are tiny? Does it have symbolic importance? What it does have is an probably unintended effect on the detention criteria themselves. And this is very interesting and creates a real dilemma in Irish mental health law. Oh, that's my unhappy face, or my puzzled face, rather. And this will appear a number of times over the course of the next 15 minutes or so. So I am a little bit puzzled about the purpose of this until you go back and look at the detention criteria to begin with. In Ireland, someone can be detained in a psychiatric hospital where, because of their illness, there is a serious likelihood of causing immediate and serious harm. They must have mental disorder and risk of harm. Okay? That's one way to get detained. Another way, well, I'll talk about that way first. There's something very interesting missing from that requirement. Can anyone give a guess what it is? You'd need to know a little bit about the mental health law. But there is no requirement that treatment or detention benefits the patient in any way in that right up there. You'll note. They just need to have mental disorder and there needs to be risk. What does the new the 2015 Act do to this? It means a detained person with mental capacity who declines all treatment can be detained indefinitely but cannot be treated. Because if the detained person has mental capacity, the detained person can decline all treatment at this point. And yet the law allows that person to be detained. Now that's not to say one must detain such a person. There is considerable discretion on the part of a psychiatrist whether someone is detained or not. But the history of psychiatry isn't exactly thrilling in this regard, to say the least. And if powers exist, they tend to be used. The other way to get yourself detained is to have mental disorder, and because of it, judgment is impaired, and failure to admit the person would lead to a risk of harm, and you'll see this criterion has a second part which says treatment must benefit the person. So that is important, okay? What does the 2015 amendment mean here? Well, if we look at the benefit criteria, a detained person with mental capacity under this section who declines medication and ECT must be discharged or become a voluntary patient unless other forms of treatment meet the benefit criterion. So because the benefit criterion doesn't apply to everyone detained, the 2015 Act creates a real dilemma. The solution, however, I do have a solution. In contrast to José, we do have a solution, and to this we need to look to the careful deliberations of the expert group on the Mental Health Act, and we can lay the blame for this at the with Professor Donnelly here, who sat on that. This was a review of the Mental Health Act, and what this did, and I think very sensibly, I think there was fair agreement on this, was it introduced a benefit criterion for everybody. And if this is brought into force, it means that anybody can only be detained if treatment would be likely to benefit the person. So in terms of the 2015 Act, all it does is underline the necessity for this very clearly by fouling up the detention criteria and creating really unthinkable things like detention without treatment. But it doesn't really do much in its own terms. And that's one of the frustrations one has as a practicing psychiatrist, is this disjunct. Like, there are changes that need to be made, and yet the one that was made is likely to have minimal effects on clinical practice. And I'll come back at the end to what changes I think are needed. Now, of course, the whole idea of mental health law could be blown out of the water by the Convention on the Rights of Persons with Disabilities if some people with mental illness are considered to be people with disabilities, which, as far as anyone can figure out, they are, at least some people. The CRPD says that persons with disabilities enjoy the right to liberty and security of person. That is my happy face, indicating I agree with the statement that has just appeared. And it also says that people with disabilities cannot be deprived of their liberty unlawfully, and any deprivation of liberty needs to be in conformity with law, and the existence of a disability shall in no case justify a deprivation of liberty. So this means we cannot link a deprivation of liberty with the presence or absence of a mental disorder. There we go. So this places obviously the Ireland's Mental Health Act and mental health law in England and Wales and Scotland and Northern Ireland and pretty much everywhere inconsistent with Article 14. It's hard to know, does this mean an end to the idea of psychiatric detention? It certainly doesn't support linking detention with the presence or absence of an illness. And if that link goes, then psychiatrists are not interested in being the ones doing the detaining. As in, psychiatrists should only be interested in detaining people that we can treat and make better, as opposed to just detaining people if it's delinked from the presence or absence of a mental disorder. Which brings us to the second legislative change I want to mention today, and talk again about the disjunct between the law and practice, and this is at a much bigger level, really. The Assisted Decision-Making Capacity Act is a very welcome piece of legislation. It's something I'm very optimistic about that I think can work, but there are big problems with it. As I said, it was signed but not yet commenced, and it introduces 3 levels of decision-making support. Okay, now a lot of you are familiar with this, so I'll just run through it briefly. A decision-making assistant is someone who will help you out with a decision, perhaps provide some information, talk things through, but it's still the person themselves who makes the decision. The next level up is a co-decision maker, and this is an interesting, poorly defined category in some senses, whereby if I appear to have impaired capacity for a decision, I can engage a co-decision maker, possibly a family member, to provide information, assist me with my thinking, and to jointly make the decision with me. It is joint decision making, which is very, very interesting because so let's say José here became my co-decision maker. He could advise me, give me information, but at the moment of decision making, he must acquiesce with my will and preference. He cannot be different to my will and preference. After the decision, he has some role in ensuring the decision is carried out. So he's like a decision-making assistant, but only more so before and after the decision. But at the moment of decision-making, he must still acquiesce to my will and preference. And the decision is regarded as a joint decision nonetheless. So it's an interesting category. Now, for this to happen, a medical doctor needs to state the following. For me to get a co-decision maker, I'd need to go to a doctor, let us say Dr. O'Keefe, and he would need to provide a statement saying that I have capacity to enter a co-decision making agreement with José, that I require assistance in making decision in the relevant area. So I have capacity to make the co-decision making agreement with José, but I lack the capacity to make the decision on my own. But Dr. O'Keefe must also state that I would have the capacity to make the decision with the assistance of José. Now, this is a very subtle judgment for Dr. O'Keefe to make. I've picked a poor example because Dr. O'Keefe probably is capable of this, but none of the other physicians in the country probably are. I know that I would struggle with this level of nuance, and this is my confused face again. This is an extremely nuanced decision for a practitioner to make. It is a tough one. And yet it is one that we're going to have to make. There are various other requirements to set up the co-decision making agreement as well. So that's the mid-level. And again, I see a disjunct here between what is asked of me as a physician and what I can actually deliver. But will we go ahead and do this if asked? Yes, we probably will. But what's even more interesting is if you look at the top, someone else has to do this too. Another healthcare professional of a class as shall be prescribed. So a doctor must make this decision. And we are used to making all kinds of peculiar decisions, like mental capacity, the capacity to own a gun, something one is asked commonly, capacity to go on an airplane, we're asked to sign forms for clothing allowances for people, like all kinds of stuff that we just do, and we probably just do this. But I don't know what other group will step in to do this. Possibly social workers, possibly nurses. They certainly haven't been consulted about it, and I'm not certain will it happen. But that's the mid-level. Those two levels can be accessed without reverting to the circuit court, but the co-decision maker may involve a court hearing if needed, if it's not instigated by the person, as does the substitute decision making, which is the third level. Now immediately, of course, we have a problem with the substitute decision making. What happens there is the circuit court needs to hear the case and either declare that the person, me, lacking capacity, would gain capacity if a co-decision maker was appointed. So that's José again. The court may decide that even with José, I would not have mental capacity. In the first instance, we'll have a co-decision making agreement with José. In the second instance, a decision-making representative or substitute decision making. Now, there are various dilemmas here. If the circuit court decides that I need a co-decision maker, it gives me time to go off and make a co-decision making agreement with José. If I fail to do that, it will go ahead and appoint a decision making representative. So there's a pretty strong incentive for me to make a deal with José. But I need to get a doctor to make the statement I said a minute ago, and it's not at all clear to me what will happen if the court tells me go and get a co-decision maker, but no doctor will sign the form. Because they don't think I meet the criteria. But anyway, let's skip that. The decision-making representative presents an immediate difficulty, as many of you will know, in terms of the Convention on the Rights of Persons with Disabilities, where the comment on it says that the development of supported decision-making systems in parallel with substitute decision-making, which is exactly what the Act does, doesn't comply with Article 12 of the Convention on the Rights of Persons with Disabilities. So we immediately have a problem with the Act, which was purportedly introduced to make us compliant with the Convention of the Rights of Persons with Disabilities. There isn't the faintest hope it'll bring us anywhere near it, and there are other problems too, such as the Mental Health Act, as I've already said. So the biggest disjunct, however, are the logistics in terms of the mental capacity legislation. How many people lack mental capacity in terms of healthcare decisions? It is a large number, let me tell you. In 2014, there were almost 18,000 admissions to psychiatric hospitals in Ireland, and around 29% of those people lacked mental capacity. There was 500,000 admissions to medical wards, and around 30% of those lack mental capacity to make healthcare decisions. And at this point in time, there's around 27,000 people in Irish nursing homes, and around 60% of them lack mental capacity to make healthcare decisions. Now, a lot of these people would probably have mental capacity with a decision-making assistant. So I'm not saying that there will be tens of thousands of circuit court cases. However, there will be a large number of such cases. And so this is a huge logistic issue for the health system in Ireland. And, I hear a lot of talk about various nuances about the legislation, but the big problem, the elephant in the room, the juggernaut coming through the train tunnel, is the size of the operation that is envisaged with the Act. And there's my absolutely horrified face. So there are some of the sort of specific legal problems. But the biggest ethical issue, certainly in psychiatry, is what I'm going to finish up with for a minute or two, if I have the time, which is that there is a much broader context to be considered here. The numbers of people affected, particularly by recent changes in the Mental Health Act, are tiny. There is a much bigger picture and a much bigger ethical issue. The overarching ethical issue in medicine, in Ireland and globally, is not touched upon at all here. I've got a picture of Ireland, so I'm taking a very broad view. I'm considering all of Ireland in this, and not just specific people. The biggest issues, the biggest bioethical issues that we face and that government faces are not these hard cases. Although important, they're not the biggest issues. The biggest issues in mental health care are to do with homelessness. If you look at how we spend our time in mental health teams, 90% of it is spent not dealing with detention or medication. It's spent dealing with social issues, homelessness, people having family difficulties with the law, patients sleeping on the streets, trying to get accommodation for people. Does this affect liberty? Very profoundly. When you look at the percentage of people in social class 10, that is very poor indeed, along the bottom, and the rates of involuntary admission. You can see that in Ireland around fewer than 20% of people are in social class 10, and the rate of involuntary admission is around 40 per 100,000 per year, which is less than England, by the way. If you move to a deprived area like the catchment area of St James's Hospital, more deprived people, more detentions. Move to the most deprived area in the country, and you can see you get more detentions again. So there's a huge social correlation between detention in psychiatric hospitals and poverty, simple poverty. Inequality as well, but simple poverty is, and some of this is mediated through mental disorder, some of it is not mediated through anything in particular. The other big ethical issue is to do with locking up people who are mentally ill in prisons. There's something called Penrose's Law. It says that as psychiatric hospitals empty, prisons, numbers of mentally ill people in prisons goes up. Here's Ireland, 1963 to 2003. You can see here the number of people in psychiatric hospitals declining, the number of people in prisons going up. What is interesting here is that even if every additional prisoner came straight from a psychiatric hospital, there still was a big net liberation. Okay, it didn't. The prison figures don't account for everybody. And we have to say this reflects an increased right to liberty for the mentally ill. This is good, but there's a real issue about the right or the expectation of treatment. If there isn't a right to treatment, there is a reasonable expectation of treatment. And my colleague here from the prison service will undoubtedly affirm that about 5% of people in prisons are actively psychotic at any moment. Over 90% have an active drug problem, which doesn't diminish in prison, it just carries on or worsens. What my chapter in the book was about migration. And in most countries you find people who are not born in a country have increased rates of psychiatric detention, and we fully expected this in Ireland too. So we did a little study. We looked at admission rates for people born in Ireland and those born elsewhere. And the involuntary admission rate for people born in Ireland in Dublin was 55 per 100,000. Would anyone give a guess of the rate for people not born in Ireland of psychiatric detention? In the UK, it's about threefold what it is for sort of native UK people. Anyone give a guess for a number here? What was it in Dublin? What am I hearing?
Tenfold.
Tenfold. Fantastic. That's the spirit. Marvellous, marvellous. Well, here we go. It's actually slightly less than people who are born in Ireland. Now, you could have knocked me over with a feather when we found this out, because the proportion of people detained from other countries is much higher than the proportion of people from Ireland, and the numbers, and the reason is this absolutely amazing statistic. What does anyone reckon, compared to 459 voluntary admissions per 100,000 population per year, what was that among people not born in Ireland? It is tiny. So what's happening in Ireland is that we are failing to make the service sufficiently accessible for voluntary care. It's fascinating. We are not disproportionately detaining people from other countries, as happens in other countries. We are failing to make voluntary engagement with care a realistic possibility. That's a far more worrying finding. As a psychiatrist, it's good. I'm interested in coercion, and I'm interested in us doing it as justly as possible and in accordance with the law, and I'm interested in how it works out. The law can be fine, but reality is something different. But so this is really interesting. This is a service problem. It's not a law problem. The law is a fairly lousy way of producing change in mental health services, and this is my horror at our failure to make our services acceptable. So these are service issues that impact on care, they impact on rights, and obviously it's underpinned by diminishing investment in mental health services, which I need to make the point, and a comparatively low investment. And this really matters more than the law matters, way more. If I go back to this graph here, look at this. Between 1963 and 2003, the number of people detained in psychiatric hospitals in Ireland fell dramatically. Much changed in those decades. Ireland as a country changed socially. Economically, we joined the EU, there was more talk about human rights, but there's one thing that didn't change one scintilla in those decades, where we saw this change in hospital populations. What didn't change? Can anyone tell me? The law. This was all under the 1945 Act. Okay, the law didn't change at all, and yet we had what can only be described as a mass net liberalization or granting of liberty to detain persons, or failure to detain new people in the same numbers. And the law, as it is written at least, had absolutely nothing to do with it. And that's the big point I want to make, is the distance between law and some of the considerations that we've been hearing and actual clinical practice, which is a highly personalized practice, and the connections between it and the law are distant and not always what one might imagine. And that's taking the All-Ireland view. Now I'm going to become ridiculously ambitious, and I'm going to take a global view. The global issue is not protection from over-exuberant psychiatrists. The global picture is that over 70% of people with mental disorder receive no treatment whatsoever. And in Western Europe, that number is at 55%. Of people with mental disorder receive no treatment whatsoever, be it counselling, cognitive therapy, or for the very small number who see psychiatrists seeing psychiatrists. So that is the global picture, and that is the single overarching bioethical issue in psychiatry at a global level. Now that's me being very ambitious, looking at the entire planet, okay? If I am to become more ambitious and look at the solar system, I can't possibly do that. I've no idea what alien life forms might be like, what kind of mental illnesses they have, although I did get guidance when I looked up on the internet preparing this talk, what mental illnesses might aliens have. I actually came across a book, a manual for the mental examination of aliens. And this is from Ellis Island, though, in 1918. So unfortunately, it's more to do with screening people going into the US than examining another solar systems. My big point to see today, though, is about clinical practice, which is that the law, particularly in mental health, is vital. It needs to provide an underpinning for detention, these enormous powers that psychiatrists have. It needs to provide review. It also needs to provide more broadly sanction for bad doctors who do bad things, through the medical council and through the courts in general. But in other matters, the law is not a very good guide in terms of individual clinical practice, which remains difficult, and it's left up to people like me. People like me. Thank you very much.